Hi, all. We're going to give it a start now. This is the 3PB Family Law Brunch. My name is Matiss Krumins. I'm one of the barristers in the family group. My main practice area is public family law, and I also practice in judicial review and Human Rights Act claims, all in relation to children and local authorities. With me is Liz Adams. She's undertaking she's a broad family practitioner doing a wide variety of things, but has a particular specialism in children with educational needs. She also undertakes educational work. I'm going to be talking to you about appeals, and she'll be talking to you about covert family recordings, which actually I'm quite interested in learning about as well. So it should be quite fascinating. And on that basis, I'm going to hand over to Liz to do her talk.
Thanks, Matisse. So, covert recordings in family law proceedings concerning children. So, this is an area that is of increasing relevance, essentially due to technological advances. And of course, there's this famous quote from M&F from Mr. Justice Peter Jackson. Advances in technology empower anyone with a mobile phone or a tablet to make recordings that would be the envy of yesterday's spies. And that was also picked up on by Sir James Munby in the judgment of Re B from 2017, who explained that actually recordings, and particular covert recordings, are nothing really new in terms of courts have had to deal with that really since the second half of the 19th century. But the prevalence of this now, and how easy it is for people to record each other without knowing, is really the key issue that the courts need to grapple with. And in the Reby case, the court was quite critical of the first instance judge's attempts to put together some guidance for dealing with covert recordings, because it recognised that there did need to be a proper review of this area by the Family Justice Council. That has now happened. So we had draft guidance a couple of years ago, but last month we now have comprehensive legal guidance from the Family Justice Council, released in May 2025. And just from the outset, my presentation draws a lot on that guidance, and I do encourage everyone to read that guidance in full. It applies specifically to recordings made by private individuals. So whilst it does mention a few things relating to professionals recording, it doesn't sort of go as in depth as it would need to, because of the additional statutory considerations for public bodies. And it's very clear it is not meant to be an instruction on how to obtain admissible covert evidence. Instead, what it does is identifies where there are legal ambiguities and looks at the procedure for when this evidence arises in cases, and in particular, the additional considerations where there are children involved. So, what are covert recordings? So this is the definition for legal and procedural purposes. It's obvious that what we're discussing are recordings made without the knowledge and consent of the person being recorded. But for the purposes of cases, they are regarded as documents, and they are evidence, and they are subject to all of the normal rules of evidence. It's safe to say that almost all covert recordings are hearsay evidence. So essentially, you need to also consider those rules, which I'll look at in a little bit more detail. And in particular, you need to consider the family procedure rules, specifically Part 22, which govern the admissibility of evidence in family proceedings. And of course, that means, as per 22.1, the court may control the evidence by giving directions as to the issues on which it requires evidence. the nature of the evidence that it requires to decide those issues, and the way in which the evidence is to be placed before the court. And as per FPR 22.2, the court has discretion to exclude evidence, and that includes covert recordings, if it deems that that evidence is irrelevant or of insufficient probative value. So the key point there really is, just because it's a covert recording, don't forget those normal rules of evidence, because most times they will be of great assistance if you are trying to argue for the admissibility or against the admissibility of specific pieces of evidence. So the rise of this type of evidence in family proceedings, as set out, technological advances. Oh, just go back. Technological advances make them a lot easier to obtain. There are three really different types, and it's really important in terms of the considerations that the court will have to determine whether they should be admitted. And those will be parents recording each other, or another sort of adult private party, like a grandparent or something. Then there's the recording of professionals, so social workers, a family court advisor from CAFCAS. And then there are recordings from children. Now, recording of professionals is a growing phenomenon, and organisations have identified a few reasons why that might be, which those of you who do public law work will probably be familiar with. So parents might not trust or want to rely on notes of meetings. They might not want to wait for notes to be sent to them. It might be that they've had previous experience of not having notes sent when they were told that they were going to. They might be worried about how hard it's going to be to challenge inaccuracies or omissions in those notes. They might want to gather evidence for their use in court proceedings, and they might also want to use recordings for other reasons, so such as being part of a campaign group, or to publish on social media. So those do need to be, if a professional has concerns that that might be the case, those need to be identified. And the case law and the guidance are very clear that when it comes to covert recording of children, it is almost always likely to be wrong, and it's the issues in terms of the impact on the welfare of the children mean that they're likely to be viewed highly negatively by the courts. There's also the risk of the impact on litigation overall from the rise in use of these recordings. And so the courts are likely to be using this guidance and applying this guidance meticulously in order to try and mitigate against issues like having to increase hearings or increase costs. So a big issue is whether it is lawful to actually make these recordings. Where it's a private individual that's made the recordings, it's an extremely complex legal area. So there are Article 8 considerations in terms of rights to privacy, but family members are not generally bound by needing to abide by those human rights obligations. There are still also GDPR and data protection obligations. Very, very important that public bodies are constrained by the Regulation of Investigatory Powers Act 2000. They are also under a duty to abide by and uphold Article 8 right to privacy. And the necessity of any covert activity has to be evidenced and proportionate. So the Family Justice Council guidance specifically notes that it is not intended to consider the implications and the practice of public agencies, which includes local authorities. So if a local authority is looking for any guidance as to where it's an exceptional situation that they might be able to engage in covert surveillance or recording, this guidance won't assist on determining that. They'll need to be specialist legal advice sought. And it's really important to note that failure to adhere to that statutory framework comes with very serious civil and even criminal consequences. In terms of private individuals, of course, they're not bound by the Regulation of Investigatory Powers Act. However, as part of the guidance, in implementing that, the Family Justice Council sought further information from the Information Commissioner's Office, and they have said that whereas usually if personal data is processed in the course of a purely personal or household activity with no connection to a professional or a commercial activity, it would usually be considered to be outside the scope of the GDPR, which of course comes with obligations when personal data is processed, and that's under Article 4(1). But however, if the motivation essentially for making those recordings is really important, and they've confirmed, the Information Commissioner's Office have confirmed that if that data is processed by family members but then used in a professional setting, which could be in the home but with a social worker present, then that actually may very well come under GDPR rules. They've also set out guidance on the use of detrimental use of data, and in particular, you must not use children's personal data in ways that have been shown to be detrimental to their well-being. So if a covert recording is shared with another person or professional body by a private individual, it will likely amount to a further processing of that data, and it will require a lawful basis under GDPR. Failure to process that without a lawful basis would be a breach of the Data Protection Act 2018, and the Family Justice Council have asked for further clarity and guidance from the Information Commissioner's Office on this, and it's hoped that they will provide more comprehensive guidance with some specific examples, which will be really helpful. But essentially, the issue of legality shouldn't be the sole consideration of anyone contemplating making a recording without consent. But it's very clear that even as a private individual, you can't just assume that you're not going to be exempt from GDPR, because actually that's likely not to be the case. It's still the case, of course, that you cannot make covert recordings of court hearings, and that would be a contempt of court. There's some notable case law in this area. I'll try to, I won't sort of go into massive detail on any of these, but they do highlight the different focuses between private law and public law, where the issue is the recording of professionals, whereas in private law, it'd be the recording of a parent or a child, more likely. Of course, as M&F 2016, that's a really well-known case where the father and his partner had sewn covert recording devices, essentially bugs, on the child, and had been recording all of her conversations with professionals. But in order to do that, she'd had these bug devices on her throughout the entirety of the school day, picking up all conversations. The court were incredibly sort of they were really against this for obvious reasons, and they really set out how much it would always be wrong to record a child, and there were also consequences in that case as well. ReBe, again, it's important to distinguish between open recording and covert recording. And in the nature of things, it's the latter that's more problematic. that set out a little bit more in terms of what the issues were, and that was the case that really called on the need for some specialist guidance in this area. Then there are also re children private law covert recordings adjournment to final hearing. In that case, the court permitted the mother's covert recordings of conversations between her and the father, but then discovered that these were selective and there were at least 100 other covert recordings that she'd not disclosed. So the court took the view that those further recordings might hold information that was relevant to the fact-finding process, and some of which might even benefit the father's case. And so they adjourned that case to allow the parties to review all of those recordings in full and avoid the cherry picking of evidence. So that case illustrates the can of worms essentially that can be opened up where you've got multiple recordings. In C, a child, that in that case, the court noted that covert recordings might, depending on the facts and circumstances of the case, amount to abusive behaviour. So in that case, the Court of Appeal deprecated the father's recordings of the mother and wholly supported a non-molestation injunction that was applied for on the fact of those recordings. And then you get a slightly different approach, well, not a different approach, but a sort of a different perspective on the usefulness of recordings in the latter two. So in re-F care proceedings, failures of an expert, the discrepancy between the content of a recording of a meeting with a consultant clinical psychologist and the psychologist's report led Mr. Justice Hayden to be satisfied that the mother had been significantly misquoted and adversely misrepresented. So that's a case where it really assisted in a parent being able to evidence that the psychologist had essentially misrepresented her and was able to challenge their evidence. And then in the latter case, Medway Council and A and others, that's a mother with a learning disability who was inappropriately placed in a mother and baby foster placement. It was a poor match on several fronts, but the local authority were seeking to rely on the allegations of the foster carer of inappropriate behaviour by the mother towards the foster carer and the baby. But the mother had covertly recorded the foster carer being racially abusive and hostile towards her. So those recordings were only transcribed and brought to the court's attention at the final hearing, but they proved pivotal in dismissing the credibility of the foster carer's allegations. In terms of other professional guidance, CAFCAS did have the operating framework originally released in 2014. They did an updated draft in 2017, but they hadn't updated that part since then. And it's really notable that in their guidance, and I'll read from the passage because this overall approach has been endorsed by the Family Justice Council as professionals, and it sets out we should have nothing to fear from covert recording. Our attitude should be, I am doing my job and I have nothing to hide. I can explain why I said what I said or why I did what I did. This is within the spirit of transparency in the family courts. We should always be transparent in our work to meet contemporary expectations, including being able to defend whatever we say or write in a court under cross-examination, because we're working to a professional standard on behalf of a child. In this sense, we should expect that everything we say or write could become public knowledge. So it's very clear there that professionals are expected to be open to being able to comply with requests by parents to have interactions recorded. For local authority social workers and staff, it's extremely helpful and encouraged by the Family Justice Council to have guidance and internal policies on this area. So it's good to check if your local authority has one and if it's up to date. It particularly encourages professional bodies to have a policy on overt recording, and it's recommended that professional agencies should, as a matter of good practice, develop clear policies that provide for the circumstances in which those recordings can be made by consent and how that data will then be maintained, stored, and accessed in compliance with the statutory framework. And this is noted to be beneficial for fostering trust and fostering professional working relationships with service users. It's not suggested that audio recording a meeting should be the default position of any agency, but that it is available to be utilised in specific circumstances. And I would direct local authorities in particular to section 9 of the Family Justice Council guidance to have a look at that. They also have the Nagalro guidance on recording meetings between a practitioner and a client set out at Appendix 2, which includes template letters to parents, and they also highlight the body worn camera policy statement of the Metropolitan Police as an example policy. So the response of professionals when offered covert recordings. So if it's outside proceedings, it's extremely important to be cautious before listening. So you need to get advice first, particularly if it's being offered to somebody who is a social worker or a CAFCAS family court advisor. They will need to consider, will listening to this material impact whether I'm seen as impartial, whether there are other issues in terms of might it trigger onward data protection processing issues. It might ultimately be appropriate to read or listen to those recordings. So this isn't sort of to say never listen to them, but it needs to be a considered approach, and it needs to be factored in terms of all of the circumstances of the case, whether actually it's going to assist matters, or whether by listening to it at an earlier stage will save costs down the line if it's a parent who's clearly going to be determined to raise it within proceedings. If it is raised within proceedings, the correct approach should be to see it as an issue for case management. So before listening to those recordings, the material should be put forward to the court, and the court needs to determine whether it can be admitted into evidence. So once, if somebody is trying to reduce covert recording into evidence, key here is early identification. It's very clear now from this guidance that there are a number of considerations that the court has to grapple with when determining whether this evidence is admissible. And it may very well be that it's, especially now this guidance is in place, that it's not appropriate for a court to go ahead with a final hearing when they've had this type of evidence presented to them at the morning of court or the week before. So it may very well then necessitate adjournment and massively increase costs. The court has to give directions on the method of disclosure to the recordings of the other parties, whether transcripts are required, establishing the full scope of the recordings, how they came about, which recordings need to be considered, establishing authenticity, and then establishing the probative value. And then, of course, there are further costs issues. And crucially, the court has to weigh the emotional and psychological impacts on the child and also to other parties. And just to highlight as well, it's at Appendix 3 in the guidance. There's an extract from Re M concerning the guidance in relation to intimate images, which may sometimes be the subject of a covert recording. Court's approach to admissibility, I've set out already that they're more than likely going to be hearsay unless, of course, they're relied on for the fact that somebody was recorded. and then it's so the action of recording is the thing that's an issue. For hearsay evidence, if it falls within the parameters of the Children Admissibility of Hearsay Evidence Order 1993, then it must be evidence given in connection with the upbringing, maintenance, or welfare of a child. That's a fact and case specific determination. And in that event, it would usually be admissible. However, if it doesn't fall under that and it falls under the usual Civil Evidence Act 1995, if it's also hearsay evidence, then all of the normal considerations as to whether hearsay evidence is going to be relied on and to what extent it's going to have weight placed on it by the court, all of those usual considerations come into focus. So it's a good thing to just sort of go through that act, in particular Section 4, where it's the checklist of whether hearsay evidence should be relied on, and check, because there could be some applicable arguments either in support of admitting or not admitting the evidence, depending on your client's position. If the recording could be said to amount to an examination or assessment of the child per Section 13 of the Children and Families Act. So that is, for example, in a recording where the child's being asked about specific allegations in contemplation of proceedings. And then perhaps if questions put to the child or the recording itself is then analysed by an expert within those proceedings. That Section 13(3) states a person may not, without the permission of the court, cause a child to be medically or psychiatrically examined or otherwise assessed for the purposes of the provision of expert evidence in children proceedings. So if the court decides that that section is applicable to a recording, then the default is that it would be inadmissible, and the court would have to provide reasons as to why it was going to allow it to be admitted. You should be making an application to rely on recordings via a C2, should be served on notice. It's essential that that C2 application has sufficient details to enable the court to carry out a proper determination of what factors are going to be relevant to consider whether that particular recording should be admitted into evidence. So as a minimum, it should provide a summary of the nature of the recording, its context, whether it's edited, the method of the recording obtained covertly, and the relevance of the contents to the issues in the proceedings. And late production not only risks detailing the timetable of the case, but in particular, as I've set out, apologies, there could really be grounds for a costs application. So in terms of consideration, for the probative value, really important here is that the court will need to test whether it's probative or prejudicial, and it will also need to consider whether it's been edited. And of course, this is really serious in this day and age where you can get AI and it can essentially, you could have false videos. It's really important to consider whether an expert might be necessary to offer evidence. And of course, the usual Part 25 considerations would apply in that, if that was the case. In terms of particular considerations relating to children, it's really important that the court considers whether a guardian needs to be appointed. So needs to consider whether a guardian will need to be appointed, and also needs to consider whether it will throw up re-W issues in terms of, does the child now need to give evidence on a particular recording, especially if the context of what a child was saying in a recording is an issue. Of course, it's also important in those circumstances to consider the risk of long-term emotional harm, and it's really crucial to consider whether the child needs to be told about that recording and how they are going to be informed about that recording. If any party wants or needs a child to give evidence, they will need to use a C2 to make that application. In terms of practical consequences, in terms of costs, satellite litigation, as I've set out in M&F, it was over £10,000 that were ordered to be paid in costs from the father. There's also a real risk of derivative actions. That could be civil actions. It could also be a non-molestation order. In particular, if you're acting for a client who's been recorded by somebody else, it's something to think about whether that application needs to be made. Also need to consider whether covert recordings are undermining any other evidence. So in particular, for neuropsychological assessments, the British Psychological Society have noted that deliberate covert recording is inappropriate, and any form of recording needs to be considered in light of potential threats to the validity of an assessment. So those recordings are likely to undermine the validity of the information collected. And of course, if there is a recording or questioning of a child, it could have an impact on an ABE interview or police investigations. Very briefly, the guidance also covers young people's views on covert recording, which it's no surprise that they have reported that the negative and harmful impact of covert recordings. They described feelings of betrayal and discomfort and raised concerns about the potential for manipulation and coercion. They were recognised that those recordings could be edited or scripted, might not reflect true feelings, especially where a young person's words have been attempting to placate a parent. They were more positive about overt recordings by professionals, but again, were concerned about the storage of those and whether they would be passed on to parents. This bit of the guidance in particular might be a good resource to highlight to parents who suggest that they might start to record a child, to say, you know, look, well, this is what children are overwhelmingly telling us about how they feel about being recorded. And just to note as well, at Appendix 4 of the guidance, there's a 2-page info sheet for litigants in person, which is a really good thing to be able to pass on to clients. So key summaries: legal, evidential and welfare risks from covert recordings. Early case management is essential. The courts will focus on the relevance, the authenticity and welfare issues, and professionals have to act with caution and care if you are asked to view a recording.
Thanks to Liz. That was actually really interesting. It's really useful. It comes up more and more, I think, for everyone. If you've got any questions, just remember, we can put them in the Q&A. We can see them, and then we'll be able to deal with them at the end. I'm Matiss. I'm going to be talking to you about appeals and family proceedings. This is a overview guide so that people get a bit more comfortable with the appeal process, what's expected in terms of the procedure and some of the fundamental parts of it. It certainly isn't going to cover all of it. There's a huge amount to deal with in respect of appeals and all the more complex applications in respect of it. I'm going to go through appeal procedure for you and then some principles of the appeals. So this is entirely designed to get people more comfortable with what they need to deal with, and often have to deal with that question you may face, whether you are acting as a solicitor or as counsel, when you're asked the question by a client, can I appeal this? And so you can explain to them what the process is. You may not be able to give an answer there and then, but give some understanding as to the approach to be undertaken. So looking at the appeal procedure, the question is to which court you're appealing. It matters because effectively there are going to be 2 sets of procedures you need to be aware of. Appeals within the family court, I'm going to go through which court you go to, but appeals within the family court, it's FPR Part 30. If you're going to the Court of Appeal, it's CPR Part 52. A lot of the rules are identical or very similar across the two sets of rules, but it's just knowing which structure you're functioning within. The rules matter. It is an important point here. The rules matter always, but they're very important in appeals. You'll be told to comply with those rules, and general experience is you are expected to comply with them, and they will be enforced strictly. And so the deadlines for when actions need to be taken are really important. First question you've always got to ask yourself is, which court am I appealing from? Well, actually, life is made much easier in the FPR rules. You'll find them at PD 38. Paragraph 2.1 has a route of appeals table. It's a full table set out. I can't get it to come up on the slide. By all means, you can go into the practitioner guide, the red book, and you'll find it there. That helps setting out. It sets out how it works. I've pulled one of the examples, then one of the easier examples. If you have an appeal from a High Court judge, it tells you so this is how the table works. In the middle, it says you do need permission, and it tells you Court of Appeal. It equally might say District Judge, you do need permission, and it will say appeal to a circuit judge. Depends on the type of matter you're dealing with, and it depends on which court you're actually in dealing with it. But it sets out the full. It covers almost every possible appeal from which level to where you need to go, and that'll be your first starting point to find out exactly what you need to do. Speaking of that, strict rules, we're going to talk about time limits. They are strict. They will be enforced. You normally have 21 days to appeal a decision. That does not apply if it's a case management decision. Then you have 7 days to appeal a decision. That means the application notice needs to be lodged within 7 days. Those time limits are strict. You can get them extended, but you have to seek time to extend them prior to the expiry of the time limit. The important point is, which is one of the common problems, is when the time runs from. There's quite a bit of case law about it now. I'm just going to summarize it all very simply here. The time limit runs from decision. It does not run from when you're giving a judgment. It does not run from the sealed order. So once the court has made the decision, given it to you, the time limit runs. If your judgment, I've just recently dealt with a matter where the judgment was delayed by 3 months. The time limit for appeal ran from the decision, and what we did was extend the time limit for appeal until we had the judgment. So that'd be a good reason to extend the time limit. Because the complexities in that matter delay the judgment. But equally, you don't have to wait for the sealed order, and the time limit doesn't run from that. There is some confusion in the case law. You will find, I think there is one case that certainly suggests that time limit runs from sealed order. I would approach it that the time limit runs from decision, and so be very careful about when your time limit is running. Case management decisions, particularly, if you're challenging those, you've got a very, very tight turnaround to deal with it. And then so it turns to what's effectively the process. You need to file what's called an appellant's notice. So if you're the one who's appealing, you need to lodge an N161 form. That form pretty much covers everything you need. It's a form where you fill out all the details. You can set out in the form your grounds of appeal, but you can also set those out in a different document. End of that form contains multiple checklists, depending on which court you're going to, which tell you what needs to be provided with the form. So that's often 3 copies of the judgment, 3 copies of the order. There'll be other matters. It all sort of depends on to which court you're appealing. But that checklist is really helpful. Just turn to it, gives you everything you need to do. You can go through it, mark that you've provided it all, and get the N161 into the court office. You'll find if you're particularly going to the Court of Appeal, my experience is the court office is incredibly helpful in assisting you in making sure you've got it all, you've given it all to them, and then get on with looking at your application. With the application, you need grounds of appeal. Those will be the short points setting out what it exactly is that you're appealing in the decision that's being made in the lower court. I generally, as my practice would be, I'll draft a separate document which goes with that, but they can be put within the N161. The other document that will accompany an appeal is a skeleton argument. Now, that argument can go with the notice, but you are entitled to serve it 14 days after notice. So it does depend on whether, equally, if you're going on something that needs to go very quickly, you can file a skeleton argument with it. You can equally, if it's very complicated, you may file the notice and indicate the skeleton argument is going to follow. The other thing that you've got to deal with on the form is whether you're seeking a stay of the effect of the lower court's order. That will depend on the circumstances of the case. Again, there's an entire box to set out you are or are not seeking a stay, and if you're seeking a stay, what are the reasons why you're seeking it. Of course, one of the primary arguments on appeal is if you don't have a stay of the order, it will be prejudicial to the appeal itself. Whatever decision's been made, even if you were granted appeal, can't be reversed or would have a significant detrimental impact prior to the appeal being considered. So let's bear in mind that's the document. If you're appealing, that's the document you're going to be working from and sending in. That's the primary document you'll be dealing with. I'm going to return to permission, as in what exactly permission is and how that works. But one thing you're going to need for appeal, as you'll see in the routes of appeal, is whether you need permission or not. Almost all the routes of appeal require permission. The only time you don't require permission generally is if you're appealing from the bench of a lay magistrate or a lay justice, and that appeal would go to a circuit judge, and that doesn't require permission. But beyond that, and I would generally assume that you do need permission to make an application. You make the application for permission one of two ways. You either have to make it at the lower court, to the lower court, at the hearing when the decision is made. So that can cause particular difficulties, of course, if you have a situation whereby you have a decision and the judgment's to follow. The rules are really clear. You have to ask permission at the decision. So if you don't ask it, that's not a disaster at all anymore. It used to be a problem, it isn't anymore, because you have to then use the alternative route of permission. And the alternative route of permission is that you ask the appellate court. And there's an entire section in the N161 form for you to tick and ask for permission or to indicate whether permission has been granted or not. I would always work on the assumption that permission is almost never granted unless there's a particular by the lower court, and you'll always be having to ask the appeal court for it. So if you don't ask for it at the hearing, then the only place you can get permission from is the appellate court. It's not a case of going back by email or going back by a further application for permission to the lower court judge. If it's not been asked at the hearing, that's end of. You then have to go, and generally you'll find that you'll be asking for permission from the appellate court in any event. In terms of the process, permission, if you ask at lower court, will obviously be dealt with at the hearing. If you're asking for it on the papers, you'll generally find there's two methods. You can either have it heard at a hearing or have it heard on the papers. To some degree, that's going to depend on the court you go to. If you're refused on the papers, it is possible to request an oral reconsideration of that permission application. The exception to that is the court will consider on the papers whether to mark an application for appeal totally without merit. If you're marked totally without merit, there is no recourse to having an oral reconsideration. I'm not going to go into too much detail about asking for an oral reconsideration. Just go careful thought has to be made as to whether or not there is something more that can be set out that assists the case to argue in front of a judge to reconsider the issue of permission. If permission is granted, you'll be listed through to a hearing. My general experience is if you are within the family court, so if you're in the FPR rules part 30, you'll find your permission and appeal hearing is going to be rolled up into one hearing. That is either taken as a decision for expediency, because you have an important appeal, has a direct effect upon a child, and you're going to be heard relatively quickly. I know blended family courts will also deal with permission on the papers. So it does depend, but you can, and it is not unusual to find that your permission and appeal hearings are rolled up into one. So effectively, the court will hear the entire application and then make a decision about permission and appeal in one go, i.e. they'll give a decision saying, I grant you permission, I'm now going to deal with a substantive appeal. Court of Appeal almost always considers permission on the paper. And I don't have experience otherwise. In fact, I think every application I've dealt with has been dealt with first on the papers. You'll have your papers go in, application goes in, Court of Appeal will look at it, will give it to one of the Lord Justices, and you'll get a decision back, either granting appeal. If it's granted, there'll be directions listing it to a hearing. If it's not granted, it's dismissed, and that's the end of the matter. In terms of the other side, if you receive a notice of appeal, there is what action you need to take. Responding to an appeal, you need to consider whether or not you're going to file a respondent's notice. Respondent's notice is only required if you are seeking permission to appeal yourself. So that's, you might, as a respondent, decide that you're going to appeal, but appeal on a completely different basis. Alternatively, you're going to file a respondent's notice if you're asking the appellate court to uphold the order, but for different reasons than given by the court. If you're not asking for either of those things, then you're not required to put a respondent's notice in. What you will have to consider is whether or not that you want to file a respondent's skeleton argument seeking to uphold the decision of the court. If you don't put a notice in, then the skeleton argument goes in 7 days before any hearing. If you do put a notice in, it's the same rules. You either put your skeleton argument in with the respondent's notice or 14 days thereafter. So if you're responding to an appeal, respondent's notice in limited circumstances is required. Otherwise, you're filing a skeleton argument. Substantive appeal itself, you'll have a hearing listed in respect of it, and it will be generally a single hearing. You will not hear evidence. The only time the court will hear evidence is in very narrow circumstances. I've not dealt with the issue of fresh evidence. You're not generally entitled to produce fresh evidence. The appellate court is looking at whether a decision of the previous court is right or wrong, and we'll be looking at the facts it was dealing with at that time. You can produce fresh evidence. Again, there's a complicated procedure and complicated rules in respect to that, and they require a separate application. For the substantive appeal, you'll need to produce an appeal bundle. So that's the bundle containing appellant's notice, skeleton arguments, grounds of appeal, respondents, arguments. Ideally, it's one bundle agreed between the parties. A separate bundle, that's the bundle from the original proceedings. Generally, you'll try and agree documents. You need to try and only produce the salient documents for the appellate court to consider, rather than producing a 1, 2, 3,000 page bundle with many things that may not be necessary. And then also as part of that, a bundle of authorities. Ideally, you want to agree this with the parties. If it's not agreed, unfortunately, then each party ends up filing their own bundles. But that does make it a more cumbersome hearing. So ideally, you want to agree it. So you don't really have to worry too much about agreeing a bundle of authorities. My general view is everyone will set out in their skeletons what authorities they're relying upon. Someone will agree, the appellant will generally have to deal with it. If sometimes the appellant's in person, but the respondents might be a professional body like a local authority or a children's guardian, they may deal with bundles and produce a bundle of authorities which covers all the authorities that are being relied upon in respect of it. So that's a broad overview of the process of appeal. It is both, I'm going to suggest, complex and simple. There are limited number of steps to be taken, but they will have to be carefully taken. So we're going to look at some of the principles of appeal so you get an idea of what are the issues you need to cover, particularly when asked that question, can I appeal? The fundamental test is one that is very clear, but can also cause people a lot of confusion. An appeal will be allowed if the decision of the lower court is wrong or unjust because of serious procedural irregularity or some other irregularities. So that's the only basis you can appeal. It's either the decision is wrong or there's such an irregularity in the process that's been undertaken that it renders the case unjust. You'll often hear people refer to plainly wrong. that is not the test anymore. The test is simply wrong. So the question for the Court of Appeal or the appellate court is, was the decision wrong? And then you'll be looking at factors like, is it wrong in law? Has the court applied the wrong test? Has the court taken an exercise of discretion? So where it has a discretionary decision, has it taken factors into account it ought not to have, placed too much weight on a particular piece of evidence? Has it missed out a piece of evidence? Has it missed out a piece of analysis? Those are all potential bases for establishing something is wrong. What you have to remember is the appellate court doesn't start afresh. Some of them, I'm not going to get into too much into the weeds about the various approaches to be undertaken. For example, a decision from a magistrate, often the decision from a circuit judge appeal is a fresh reconsideration, but generally it's not. And I'd assume most appeals are not a fresh decision. The appellate courts will give the lower judge a very wide discretion on the basis that they're the ones who heard the evidence, assessed the individuals, and reached the conclusions they did. So it is this test of wrong is simple, but it is also very difficult to meet because there is a wide discretion applied to judges in respect of the exercise of their discretion. Clearly, if they've applied the wrong test, then it's a much clearer path to appeal. But when it's the exercise of discretion, the appellate courts give a wide consideration. You'll often have a situation even where an appellate court may say to you, I may not have decided that, but it was within the discretion of the judge to decide that. One of the things we always have to remember is you can't appeal just because the client doesn't like the outcome. That is the question I often have at the end of cases from clients when they say, I want to appeal, I want to appeal, I don't agree with it. I said, well, unfortunately, not agreeing with it is not the reason to appeal the decision. The test for permission is granted if you have a reasonable prospect, a real prospect of success, or there's some other compelling reason. I'm not going to cover some other compelling reason. Those are generally matters of public importance. You will generally be looking at a real prospect of success. There are two conflicting cases. One from Mostyn, who effectively tells you that you, on the balanced probabilities, you have to have a likelihood of success. And then one from Moore, who says you simply have to have a realistic argument rather than a fanciful argument. The Court of Appeal, although it hasn't entirely said that Mostyn is wrong, has indicated, I'm going to suggest that they prefer the more probable or more likely than not. They've advised against a quasi-mathematical approach to it, but neither have they said, but what the Court of Appeal has not said is that it has to be more realistic than fanciful. So there is still a little bit of uncertainty, I'm going to suggest, in respect to that. One of the issues that arise often on appeals is the issue of clarification, and is whether clarification should have been sought from the lower judge. Effectively, FPR requires an advocate to bring to the court's attention before the order is drawn as to whether there's been a material omission. However, there has been now a series of judgments that have reiterated that clarification of a judgment and or further reasons should not be routine. It's a question of it being asked to address an omission, ambiguity, of deficiency in the reasoning and the judgment that's material to the decision that's been undertaken in the proceedings. Importantly, it's not an opportunity to re-argue the case, not an opportunity to reiterate submissions or to invite the judge to reconsider findings. So there has been a real pressure back not to go back for clarification, and generally you'd be asking for clarification if it's obvious that something's been missed. For example, you might have a core finding that was being sought by one of the parties and the judge hasn't indicated whether it is or is not being found. You might say it can be clarified at that point, but what you can't go back to is go, I made all these arguments and you haven't dealt with any of them. That maybe I would suggest is a attempt at a second bite of the cherry in terms of determination. the arguments were made, the court does not have to, in their judgment, set out every argument that was made by a party. They set out the reasons for their decision. Just a reminder in terms of practice, clarification needs to be by way of agreement between parties, single document, compile it. It's not an opportunity for multiple parties to be sending the judges multiple emails. That approach has been deprecated by the Court of Appeal. That's the approach for clarification. There's been some recent case law on clarification. In the case of Kindrill, it's a commercial matter. The details of the case itself are not relevant, but it reiterates this whole point about what is appropriate in terms of clarification or not. So hopefully that brings us to the end. We're just ending at the hour, so perfectly timed almost in respect to this. Thank you very much for those who have attended and listened throughout, and I hope that's helped understand some of these topics for you. Lose my Zoom screen. Just hang on 1 second. Great. I'm just going to hand over to Liz to answer some questions in respect to that topic.
Thanks, Matiss. So I've had quite a few questions in. So first one, can covert recordings be used in family proceedings, including financial remedy proceedings? And if no, what steps can an opposing party take once the recordings have been shared with the court? Under what circumstances can the court allow this evidence? So short answer is yes, they could be admissible. So you need to consider the steps as outlined earlier. So does it come under any of the hearsay rules? How is it obtained? For what purpose? Could there be any costs issues arising from the admission of the evidence? Any satellite litigation? Costs in particular in financial proceedings will be even more of an issue. Courts sort of more willing to make those costs orders, and particularly if it's coming under any of the civil costs regimes, if it's a Schedule 1 application or a Talata application, those will be even more pertinent. There is a case, it's the House of Lords decision by Lord Simon of Glaisdale in Director of Public Prosecutions in Kilburn. It's a 1973 case. Apologies, sorry, I'm reading the wrong citation. It's the Immerman and Chenguiz, so it's a 2011 case, and in that sets out accordingly. We consider that in ancillary relief proceedings while the court can admit such evidence. So that's a really good one to have a look at within the context of financial remedy proceedings. I'll just pop that citation in the chat. Delphine can pass that on. I don't have the option to type it to everyone. So if Delphine could please put that in the chat if people want the citation for that. If you are wanting to argue against an application, you could sort of consider all of the points and consider notifying the other side that if this evidence is submitted, we're going to be making a costs application or even an injunction application, if that's appropriate. So at the outset, sort of trying to dissuade them from putting that evidence in, but in principle, it's not evidence that automatically can't be put in. Matiss, did you want to sort of do one each?
Yeah, sure. See this number. If I deal with the questions about permission to appeal and timescales, I've been asked about. So firstly, is it working days or calendar days? It is calendar days. If you're 21 days, it's calendar days to appeal, not working days. That's the same for the 7 days. It's calendar days, not working days. In terms of, will a judge hear permission to appeal if you're a day late? not suggesting they won't, you will then need to apply for an extension of time and explain the reasons why you're a day late. There are often good reasons for a delay. The most common one I come across is the length of time it has taken to obtain legal aid to effectively have funds in place, the permission in place to bring the appeal. So an explanation will need to be provided. If there's a reasonable explanation for the delay, then I see no reason why the extension won't be granted. The longer it is, so there's of course the difference between being a day late and being 7 days late or being months late, and a full explanation will need to be applied to the court that you're appealing to, the appellate court. You'll need to seek the extension of time. I'll hand you back to Liz.
Thank you. So second question I have is, how would a court treat a recording from a doorbell camera? So that would really depend on the circumstances. If, for example, it was indicated to be out of order, or it was concealed behind something else, so it wasn't obvious that the doorbell camera was there, that may very well be classed as a covert recording. But say, for example, a Ring doorbell camera that's visible and is clearly operational, there's a good argument there that that's not covert at all, because people who are walking past or acting within the vicinity of where that camera might pick things up will need to be aware that they may very well be being recorded. So yeah, that one will be very fact specific, and the court will need to analyse that in the same way that it will analyse any other application. In particular, if there's an argument there that it either is or isn't covert recording, make that really clear on the C2 application. And if you're sort of trying to say, actually, this isn't a covert recording and this is why, set that out in full on that C2.
Thanks, Liz. I'm going to deal with again matters of time limits in respect of respondents' notices have been asked. When does the respondent's notice go in? That is relatively straightforward, but there are several caveats. The respondents go to notice, you have to file it 14 days. Sorry, it's generally 14 days, but the lower court can set an alternative date. But if there's no date from the lower court, generally there won't be a date from the lower court. But it's 14 days from or when you receive service of that appellant's notice and permission is not required, or the date 14 days from when you receive notice of a hearing that's going to be rolled up to deal with permission and appeal. So there's always 14 days. There are several things that will trigger it. So it depends on the individual case. And those, you'll find those all, they're set out in FPR 30.5. So you don't have to rely upon trying to remember what I just said in respect to that. If I just also deal with the question about if a judge refuses permission, can you seek permission from the Court of Appeal? And the answer is, well, sorry, just to be clear, if the lower court, i.e. the court which made the decision, refuses permission, yes, you can seek permission from the appellate court. If the appellate court refuses permission, you cannot seek secondary appeal permission then. If you have permission refused by an appellate court, you can't then seek permission to appeal that decision. I hope that's clear.
Thanks, Matiss. So I've had quite a specific question here. So 14-year-old daughter recorded her father in covert video as was confronted by him unexpectedly after school on her walk home to talk about his conflict with mother. rechild arrangements with the daughter. She did it as felt unsafe slash unsure, although it is in public. Can I utilise the video slash send to the solicitor as evidence of his inappropriate behaviour? So obviously it's difficult advising, usual caveats because it's quite a specific scenario and don't have all the details of the case. But in this instance, I would be concerned about what the implication is going to be in terms of whether this child is going to need to give evidence about that video if she was the one that actually recorded it. Is there a guardian instructed? Has there been a CAFCAS report? Sort of what other involvement has there been to ensure that the child's wishes and feelings have been known to the court? Because if the child themselves is taking this action, it suggests that there's a real issue in that respect. So it may very well be that there does need to be consideration about that. In terms of using the video to send to the other solicitor, it would certainly need to, if you were sort of wanting to use that within proceedings, raising it at the earliest possible opportunity would need to happen. And really, the court should be the court should be notified at the earliest possible opportunity as well. If it's sort of without, if the parties are not yet in proceedings, and this is a case of it's beforehand and there's kind of a situation brewing, it may very well be appropriate to say, but you would also need to consider whether there could be any potential risk to the child of alerting dad to the fact that the child had made this recording as well. So there really does need to be a very thorough review of all of the welfare issues involved, and all of the risks to that child before using that recording, in my view.
Thanks, Liz. I'm going to answer some more questions about the process for extensions of time, and I'll make this very clear. The rules are clear. The only court that can give you an extension of time is the appeal court. So the lower court can't give you that extension. Any extensions of time to any parts of the process, appeal court has to be by application. You cannot agree it with the other side. So the appeal court needs to authorise it. If it's an application for extension for permission, you can ask for that. There is a particular tick box and box on the M161 for an extension of time for filing of the appeal notice. When you will, if you need to seek it, you have to tick it and set out the reasons for it, and the court consider those reasons when they consider the issue of permission. So that is when you generally be asking for it. Otherwise, I would recommend hitting timescales.
Thank you all so much. And just to let everybody know that we will be now closing for the summer. So there won't be any family law brunches in July or August. We will resume them in September, and everybody will receive the invitation when they resume. But thank you all again for your attendance.